Welcome to the Deep Dive, the place where we cut through the noise and take the most complex legal and constitutional concepts, the ones that, truly govern your everyday interactions with the state, and give you the in-depth knowledge necessary to understand them.
Today, we are focusing on one of the most critical personal defenses you possess in the face of governmental power. That's the Fourth Amendment. This is the constitutional shield that protects your home, your car, your documents, and maybe most importantly now, your digital life from arbitrary searches and seizures.
Our mission today is pretty ambitious. We are taking a deep dive into the history of this amendment, tracing its evolution from protecting physical property to protecting modern digital privacy.
And we'll unpack the strict requirements placed on law enforcement.
Right, and perhaps most importantly for your daily life, the many, many exceptions the courts have carved out that allow police to act without a judge's pre-approval.
We've relied on some exhaustive legal analysis, drawing heavily from core Supreme Court annotations and foundational legal history from sources like the Library of Congress. These documents, they really illustrate a constant tension.
A tension between what, exactly?
A tension between the public's need for safety on one hand and the individual's right to security and privacy on the other.
At the heart of this entire discussion are the two clauses that make up the Fourth Amendment. I mean, these are really the twin pillars that frame every case we're going to talk about. First, you have the general guarantee, the right of the people to be secure against unreasonable searches and seizures shall not be violated.
And second, the warrant clause. This is the part that dictates the procedure if the government wants to conduct a search legally. It says warrants must be based on probable cause, supported by oath or affirmation, and they must particularly describe the place to be searched and the persons or things to be seized.
So, unreasonable is prohibited, and warrants have to be specific. That dynamic, that balance between security and specificity, is the foundation of everything we need to understand about constitutional privacy today.
Absolutely. So let's unpack this history, starting with a principle that's, it's older than the country itself.
Okay, where are we starting?
If you want to understand American constitutional privacy, you really have to start in 17th century England with a legal concept known as the castle principle.
Every man's house is his castle. It's one of those beautiful, strong legal maxims, right? Where did that actually originate, and what did it mean in practical terms against the king?
Well, that concept was popularized way back in Semane's case in 1604, and it was fundamentally about the sanctity of the home. The ruling established that even the king, through his agents, could not just enter a person's dwelling without a lawful justification.
So it basically cemented this idea that you had the right to resist and defend your home against someone just walking in.
It did. It sets up the idea of a physical barrier, a line the government cannot arbitrarily cross. It essentially defined the home as the first sphere of personal liberty.
But the ruling didn't say the king could never enter. Right?
No, absolutely not. It recognized that officers could still enter for a lawful purpose, to execute a warrant, for instance. But the key was that the entry had to be justified. It couldn't just be on a whim. It was a crucial early limitation on state power.
But as history shows us, power, once you grant it, it tends to push against those limits, which I think leads us directly to the American colonial grievance that birthed the Fourth Amendment, the notorious writs of assistance.
Yes, and these writs were the complete antithesis of the castle principle, the exact opposite. They were general warrants issued by the British Crown to customs officers in the colonies, and they didn't specify a location or a person or a thing to be seized.
So it wasn't just vague, it was essentially a permanent license for an officer to just rummage.
Exactly. These writs were valid for the entire lifetime of the reigning sovereign, plus 6 months after. Yeah. They authorized officers to enter any house or building at any time within their district to search for and seize goods they thought duties hadn't been paid on. It was arbitrary power in its purest form.
I mean, just try to imagine that. Imagine police being allowed to enter your house, your car, your workplace, simply because they felt like searching for something, without needing a specific reason for you or your property.
It would be devastating to commerce, to personal security. If you were a colonial merchant, you could be constantly subjected to these indiscriminate, invasive searches, and that's exactly what happened.
And this all came to a head, didn't it? There was a specific moment.
There was. When King George II died in 1760, all the existing writs expired. They had to be renewed under the name of the new king, George III. And this procedural moment triggered this famous legal challenge led by James Otis in 1761.
Otis, what was his argument?
He attacked the writs, arguing they were the worst instrument of arbitrary power, totally subversive of the liberty of the subject. And John Adams, who was there, he recalled that moment and famously said that in Otis's argument, the child independence was born.
So the lesson from that colonial experience was paramount. The government can never have discretionary power to intrude. Any intrusion has to be specific. It has to be justified by individualized suspicion and authorized by a neutral party.
And that foundational purpose was established: protection against arbitrary physical invasion. But as the 20th century dawned and technology advanced, the law really struggled to apply that castle principle to things that weren't, physical places.
And that marks this really crucial legal shift, because early on, the courts had a very narrow, very restrictive view of what a search even was. It was all defined by property law. The only question was, did the government literally trespass?
That was the trespass test. And we see this play out perfectly in the 1928 case, Olmsted v. United States. Federal agents had installed wiretaps on telephone lines outside Olmsted's office and his home. They got mountains of evidence against him for conspiracy to violate the Prohibition Act.
Okay, so a clear invasion of his private conversations, but no invasion of his physical property. What did the Supreme Court say?
They held there was no Fourth Amendment violation.
Why?
Because the officers never physically entered Olmsted's home or office. The wiretapping took place on public property. Since there was no technical physical trespass upon his tangible property, the Fourth Amendment just didn't apply. The constitutional protection was seen as a guardrail for physical stuff, not for intangible conversation.
That seems completely inadequate for the modern world. I mean, if that standard had remained, every email, every text, every phone call would be completely unprotected.
It was totally unsustainable, and that inadequacy finally led to the landmark decision that changed everything, Katz v. United States in 1967. This case effectively abolished the trespass test, and really it revolutionized the definition of a search.
Okay, let's focus on the facts here, because they're so relatable. What was Mr. Katz doing, and how did the government track him?
So Katz was placing illegal gambling wagers across state lines using a public telephone booth. Federal agents, without a warrant, attached an electronic listening device, a bug, to the outside of the booth.
To the outside.
To the outside. So again, no physical entry into the space. They just recorded his half of the conversations.
So the government's argument must have been no physical trespass, no search, just like in Olmsted. But the court disagreed profoundly, and they shifted the focus from protecting places to protecting people.
Correct. The court recognized that when Katz entered that booth and he closed the door and he paid the toll, he was seeking to preserve his conversation as private, even though the booth itself was publicly accessible. The key principle they established was the Fourth Amendment protects people, and what a person seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected.
And this is where the specific test for constitutional privacy comes from, isn't it? The famous two-pronged test, often called the Katz test.
Yes, often articulated through Justice Harlan's concurring opinion, which became the standard, to determine whether the Fourth Amendment is even implicated, whether a search even occurred. We have to ask two questions.
Okay, what are they?
First, did the individual exhibit an actual subjective expectation of privacy? Did they personally take steps to make the area private, like closing the phone booth door?
And the second?
Second, is that expectation one that society is prepared to recognize as reasonable? This is the objective prong. It's the critical societal check on the first part.
And that second prong is the real gatekeeper, because I might subjectively feel my conversation shouted in the middle of Times Square is private, but society and the courts would universally reject that as unreasonable.
Exactly. The subjective expectation is pretty easy to meet. You just have to intend for it to be private. It's the objective societal reasonableness test, where the courts have to weigh the circumstances, public norms, and potential government interests. And this is the test the courts have been grappling with for over 50 years, especially as technology just continues to blur the lines.
Right. So the moment Katz defined privacy as an expectation, the courts basically set themselves up for this endless struggle against emerging technology. Our phones, our data, our digital footprints. They're now the most intimate parts of our lives, but they live on third-party servers.
And that's a classic dilemma. When the framers wrote the Fourth Amendment, they were thinking about, physical documents seized from a physical desk.
Right.
They were not thinking about gigabytes of data. So the court has to move cautiously because, as one of our sources noted, the judiciary risks making a huge error by elaborating too fully on the Fourth Amendment implications of new technology before its role in society has really become clear.
So let's talk about the immediate problem that modern tech poses: the third-party doctrine. This is the rule that has, for a long time, protected the government's access to our outsourced data.
The third-party doctrine is pretty simple at its core. If you voluntarily disclose information to a third party, you generally surrender any reasonable expectation of privacy in that information.
So historically, that meant your bank records of the phone numbers you dialed?
Exactly. Even data you upload to a cloud server were all fair game for the government without a warrant because you knowingly gave that information to the bank or the phone company.
But modern data accumulation makes this old doctrine terrifying.
Yeah.
Your phone company doesn't just know the number you called. It knows where you were when you called it, where you went next, and where you slept last night.
And that's the qualitative difference the Supreme Court finally had to recognize in the 2018 case, Carpenter v. United States. The question was whether police needed a warrant to obtain historical cell site location information, or CSLI, from a cell phone provider.
And CSLI is what, exactly?
It tracks your phone's interaction with cell towers, and in doing so, provides this incredibly detailed record of your physical movements.
So if we were just following the old third-party doctrine, Carpenter should have lost. He voluntarily gave that location information to the phone company just by having his phone on.
He did. But the court recognized that the sheer volume, the detail, and the unavoidable nature of CSLI makes it fundamentally different from a handful of bank statements or a list of dialed numbers. They held that tracking a person's physical movements through CSLI constitutes a search under the Fourth Amendment.
So why did they draw the line there? What made CSLI cross that threshold into a reasonable expectation of privacy?
The court found that CSLI creates an all-encompassing record of where an individual's been. It tracks your movements nearly exactly, and it operates both prospectively and retroactively over potentially years of data. This record reveals the privacies of life, things like medical appointments, political activities, familial habits, that you never willingly expose to the public eye.
That's a critical distinction. The court essentially said that even though you volunteer to use a cell phone, you don't volunteer to create a perfect, comprehensive, digital diary of your physical life that the government can just access without probable cause. They're protecting the totality of the record, not just the individual data points.
Precisely. It shows the cat's test adapting. Society is prepared to recognize a legitimate expectation of privacy in that comprehensive record of your physical movements, even if the individual pings themselves are technically exposed to a third-party company. And this represents a monumental shift away from the strict application of the third-party doctrine.
So, if that is where the line is drawn for comprehensive tracking, where does it still hold that if you expose something to the public, you have no protection?
The rule is still very firm. If you expose something knowingly to the public, you forfeit protection. This covers simple, easily observable actions.
Give us the classic examples that still stand today, even with the Katz and Carpenter revolution.
Okay, the classics remain. First, information you actively give to a third party that is not comprehensive tracking, like the numbers you dial or the metadata of your text messages, though that area is still being litigated.
Okay.
Second, bank records and checks information that is necessarily disclosed to the bank to conduct transactions. Third, and most famously, garbage left curbside for collection, as established in California v. Greenwood.
Ah, the garbage case. The logic being that once you place your trash on the curb, ready for the garbage collector, you have willingly exposed it to the public, whether that's raccoons, your neighbors, or the police.
Precisely. The court held that society is not prepared to recognize an expectation of privacy in refuse left in a publicly accessible place. The same logic applies to aerial observation of open fields from public airspace using the naked eye. If a plane can see it from up there, you haven't taken adequate steps to make it private. The privacy expectation just isn't there.
Okay, so we've spent a lot of time establishing what is protected, your reasonable expectation of privacy, your digital life, your physical home. Now let's pivot to how the government legally overcomes that protection. The answer lies in those two core requirements: probable cause and the warrant.
These are the constitutional prerequisites for most searches and arrests. If the government is going to intrude into your life, they have to be able to justify it with more than just a guess. Probable cause, or PC, is that standard.
It sounds like a really high bar, but how does PC compare to the standard needed to convict someone, which is beyond a reasonable doubt?
It is significantly lower. Significantly. It's also lower than the preponderance of the evidence standard used in civil cases. PC is a common sense standard. It deals with probabilities, not hard certainty.
So if I were explaining this to a neighbor, how would I define the legal threshold?
You'd use the prudent man standard. Probable cause exists if the facts and circumstances known to the officer would lead a prudent man, a reasonable, cautious person, to believe one of two things.
Okay.
For an arrest, that a crime has been committed by the person to be seized. For a search, that specific items of contraband or evidence of a crime will be found in the location to be searched.
So it's basically more likely than not that evidence is there, but it doesn't need T to be like 51%. It just needs to be a substantial chance that a prudent person would act on it.
Precisely. It requires facts, not just hunches. Officers have to present sworn testimony, usually in an affidavit, detailing the underlying facts that led them to conclude that PC exists.
And what if the officer is relying on an anonymous tip or an informant? How does a judge decide if that information is reliable enough to meet the PC threshold?
Well, that's judged by the totality of the circumstances test, which was established in Illinois v. Gates. Before that, courts used this very rigid, two-pronged test focused only on the informant's credibility and their basis of knowledge. Gates softened this, allowing magistrates to just consider all the available information.
So the judge doesn't have to check every single box perfectly, they just look at the entire picture presented by the police.
Correct. The magistrate can look at how well the informant predicted future actions, how detailed the information was, whether parts of the tip were corroborated by the police investigation, and the general reliability of the source. If, taken all together, a common-sense judgment confirms the existence of PC, the standard is met.
So once probable cause is established, the next crucial step is securing the warrant. This is really the heart of the Fourth Amendment's original intent, insulating the citizen from police discretion.
The warrant requirement is fundamental because it requires a neutral and detached magistrate interposed between the police and the public. The Supreme Court has consistently held that searches conducted with a judicial warrant are strongly preferred, even if there might be exceptions to bypass them.
Why is that separation of powers so vital here? Why can't the officer, who presumably has all the facts, just make the PC determination themselves?
Because the police officer is, by necessity, a motivated actor. They are, as the court says, engaged in the often competitive enterprise of ferreting out crime. Their focus is securing a conviction, and that motivation could lead to bias or, overly optimistic conclusions about the evidence they have.
The magistrate, on the other hand, is supposed to be detached and impartial.
Exactly. The magistrate ensures that the legal inferences, the objective decision about whether probable cause is truly present, are drawn by someone who has no stake in the outcome.
Yeah.
And the warrant also has to satisfy that particularity requirement we mentioned.
Right. It has to describe the place and the things to be seized with enough detail to prevent a general exploratory rummaging.
And that harks back directly to the writs of assistance. The warrant acts as a strict set of instructions. A warrant for stolen televisions does not allow police to search through jewelry boxes or tiny drawers because televisions can't fit there. So the rule is clear: police must, whenever practicable, obtain advance judicial approval.
The question, though, is how often is obtaining that approval deemed impracticable?
And that takes us to the most relevant section for anyone listening.
The exceptions.
The exceptions. We've established the ideal scenario warrant plus probable cause, but the majority of police interactions, traffic stops, and immediate entries happen without a warrant. These are the constitutional shortcuts, provided they meet a very specific, strict standard.
But even without a warrant, the search still has to be reasonable, right?
Absolutely. The police must still demonstrate the search was reasonable under the Fourth Amendment, often by proving probable cause or a lower standard of suspicion.
Okay, so let's start with the clearest exception: the genuine emergency, or what the courts call exigent circumstances.
This is the constitutional permission to act when the exigencies of the situation are so compelling that there's no time to get a warrant. But it's a strict standard. The emergency has to be real and immediate. The police can't create the emergency themselves to justify the search.
And there are a few types of these emergencies, right? The first is probably the most noble: saving a life.
Yes. Number one is providing emergency aid. If officers have an objectively reasonable basis for believing an occupant is seriously injured or is threatened with imminent injury, they can enter without a warrant to help. This could be hearing screaming, seeing signs of violence, that kind of thing.
The second relates to police chases. I can't just run from the police and be safe once I get inside my house.
That's right. Number two is hot pursuit of a fleeing suspect. If police start an arrest of a suspect in a public place and that suspect retreats into a private place, police can follow immediately. The public interest in preventing the suspect's escape outweighs the need for a warrant in that fleeting moment.
And the third, which is probably the most heavily litigated in drug cases,
is the prevention of imminent destruction of evidence. If police have probable cause that evidence of a crime is inside a home, and they have reason to believe that delaying the search will result in the immediate destruction of that evidence, a warrantless entry may be justified.
Tell us a bit more about that one. The facts of the Kentucky v. King case were really interesting because the police themselves sort of triggered the noise that suggested destruction.
They did. In Kentucky v. King, police pursued a drug suspect into an apartment building. They smelled burning marijuana coming from one apartment, so they knocked loudly and announced themselves. Right. And then they heard noises consistent with evidence being rapidly destroyed. Items being moved, maybe flushed down a toilet, so they kicked in the door.
The defense must have argued that the police, by knocking and announcing their presence, created the exigency.
That was the core dispute. But the Supreme Court ultimately sided with the police. They held that the warrantless entry was justified, provided the police conduct that led to the exigency, in this case just knocking on the door, was itself reasonable and didn't violate the Fourth Amendment.
So since knocking on a door isn't illegal, the subsequent sounds of destruction created a genuine emergency.
Exactly. The takeaway here is that the emergency has to be genuine, but the courts give police some flexibility if they encounter unexpected, time-sensitive circumstances while legally doing their job.
Okay, let's move to the next major exception, and probably the simplest to understand: consent.
Right. You have the right to security from unreasonable searches, but you can waive that right. If you voluntarily consent, no warrant or probable cause is needed.
This is the constitutional invitation. If I invite the police in, the shield of the Fourth Amendment just drops, at least for the scope of the invitation. But how do we define voluntary in the context of a law enforcement encounter? There's an inherent power imbalance.
That's the challenge. The prosecution has the burden of proving that the consent was truly voluntary, based on the totality of the circumstances. Courts look at factors like the person's age, intelligence, education, whether they were in custody, whether they were threatened, a whole range of things.
It's a case-by-case analysis. What is the single biggest difference between consent searches and the rights we associate with confessions, like our Miranda rights?
The Miranda difference is huge. For a confession to be admissible, police have to inform you of your right to remain silent and your right to an attorney. For a consent search, police generally do not have to inform you of your right to refuse consent. That was established in Schneckloss v. Bustamante.
Wait, so the police could just ask, "Do you mind if I search your bag?" And if you say, "No, go ahead," that waiver stands. Even if you had no idea, you could have just said, "No, I refuse."
Correct. While a lack of knowledge is a factor in the totality of the circumstances test, it's not the deciding factor. The core issue is whether the consent was the product of coercion. If an officer says, "We have a right to search your home now," and you yield, that is likely coerced. If they just ask and you agree, that waiver is typically valid.
What about third-party consent? Can my roommate consent to a search of my desk? Or my landlord for my apartment?
The rule is that consent can be validly given by someone who reasonably appears to have common authority over the premises. Common authority means mutual use of the property and joint access or control. Your roommate probably has common authority over the kitchen or living room.
But not my locked bedroom.
Exactly. Generally not your private, locked spaces, and a landlord rarely has common authority over a tenant's apartment, so their consent is usually not enough. And what's more, there's a doctrine of apparent authority. If the police reasonably believe the person has authority, even if they're wrong, the search can still be valid.
Okay, let's move to vehicles, where the rules of constitutional privacy are distinctly different and a lot weaker than they are for your home.
They are, and the Supreme Court justifies the difference based on two core rationales. First, a car's ready mobility.
It can drive away.
It can drive away while police wait for a warrant. And second, a car operates on public roads, subject to extensive government regulation, leading to a diminished expectation of privacy.
And this diminished expectation creates the automobile exception. How does that work?
If police have probable cause to believe contraband or evidence of a crime is located in the vehicle, they can conduct a thorough, warrantless search of the entire vehicle, including any containers inside it that might contain the object of the search.
So if they have probable cause that there are drugs in the car, they can search the glove compartment, the trunk, a backpack, and the back seat.
Right, and the exigency is inherent. They don't have to prove the car was about to drive away. The mere fact that it could is enough. And they don't even have to do the search on the roadside. They can impound the car, take it to the station, and search it later without ever getting a warrant.
Now, let's distinguish between a full search and the initial stop. Officers need probable cause to search. But what do they need to legally stop the car in the first place?
They need a lower standard: articulable and reasonable suspicion. If police have a reasonable suspicion of a traffic violation or criminal activity based on specific and articulable facts, they can temporarily stop the vehicle. And that is a seizure of both the car and everyone in it.
So passengers are seized too?
Yes. Both the driver and the passengers are legally seized from the moment the car stops. They can all challenge the constitutionality of that stop. If the stop was invalid, any evidence that came from it could potentially be excluded.
We also mentioned that police discretion is limited here. They can't just stop cars randomly.
That's vital. Random discretionary stops are generally prohibited. But the courts have carved out exceptions for fixed checkpoints, like sobriety checkpoints or border control stops, where the purpose is public safety, not general crime fighting, and the selection process isn't up to the individual officer.
And that standard of reasonable suspicion brings us to the lowest constitutionally permissible intrusion on the street, developed in the landmark case, Terry v. Ohio.
This is how police can briefly detain and search you on the street without probable cause. It breaks down into two parts: the stop, which is a seizure, and the frisk, which is a search.
Okay, so the stop requires reasonable suspicion of criminal activity. And this has to be based on specific facts like nervous behavior, casing a location, not just a hunch.
Right. And it's a brief detention where the person isn't free to leave. The bar for reasonable suspicion is significantly lower than probable cause. It's a minimal level of objective justification. It just means the officer has observed something specific that suggests criminal activity may be afoot.
And once that stop is legally made, the right to frisk does not automatically follow, right? The frisk is a separate action.
Exactly. The frisk is the physical search, and it's only justified if the officer reasonably believes the person is armed and presently dangerous. The purpose is not to look for evidence. The purpose is solely officer safety.
So if an officer stops me on suspicion of, say, pickpocketing, they can't frisk me just to find stolen wallets. They have to believe I pose a threat to them.
Correct. The search must be narrowly tailored. It's a limited outer pat-down of the clothing, designed only to discover weapons.
What happens if, during that weapons pat-down, the officer feels something that is clearly not a weapon but is immediately recognizable as contraband?
That falls under the plain field doctrine. If the item's incriminating character is immediately apparent to the officer's sense of touch during the lawful pat-down, they can seize it. But, and this is crucial, they cannot engage in any further manipulation. They can't squeeze it or shift it around to figure out what it is. The recognition has to be instant.
A crucial distinction. Okay, now we move to a category of searches completely divorced from the goal of fighting crime: the special needs doctrine.
Here, the warrant and probable cause requirements can be dispensed with entirely in contexts where there are special needs beyond the normal need for law enforcement.
So we're talking about places like airports, prisons, government workplaces, and schools.
Exactly. And in public schools, the standard is lowered dramatically. School officials don't need probable cause to search a student. They only need reasonable suspicion. That's from the case New Jersey v. TLO.
But the search still has to be connected to the level of suspicion. The invasiveness has to match the potential crime. This is where the facts of the Redding case become so important.
Safford v. Redding is a powerful example. School officials had a tip that a 13-year-old girl, Savannah Redding, was giving prescription-strength ibuprofen pills to other students. They searched her backpack, which was permissible, but when they found nothing, they conducted a strip search.
That escalated dramatically. What did the Supreme Court decide?
The court found that the strip search violated the Fourth Amendment. They acknowledged that the initial suspicion was reasonable enough for a backpack search. But the suspicion that she had some ibuprofen did not present a high enough risk of danger to justify the extreme degree of intrusion of a strip search on a middle schooler. The invasiveness has to be matched to the object of the search and the degree of danger.
To complete our discussion of what is and isn't protected, let's circle back to the geographical areas the Fourth Amendment explicitly ignores: regardless offenses or no trespassing signs.
This is the open fields doctrine. The Fourth Amendment protects persons, houses, papers, and effects, but open fields are not on that list. This includes pastures, woods, vacant lots, any area outside the immediate area surrounding your home.
And this brings up the necessary distinction between an open field and the protected area immediately surrounding the home. known as the curtilage.
Curtilage is crucial. It's the area immediately adjacent to the home and is considered part of the home for Fourth Amendment purposes. Your front porch, your enclosed yard.
How do the courts decide where the home ends and the open field begins?
They use 4 key factors. Proximity to the home, whether it's inside an enclosure like a fence, how the area is used, and the steps taken to protect it from observation. But even in the curtilage, police can still approach your front door for a knock and talk because any member of the public can do that.
Okay, so we've established the rules, but rules are only as strong as their enforcement. If the police violate the Fourth Amendment, what's the remedy?
That remedy is the exclusionary rule. It's a judicially created procedure that mandates that illegally obtained evidence cannot be used against the defendant in a criminal trial.
And this rule didn't always apply uniformly across the country? It started only at the federal level.
That's right. It was adopted for federal courts in Weeks v. United States in 1914. But for decades, this created a massive loophole known as the Silver Platter Doctrine.
The Silver Platter Doctrine. Explain that.
Because the Weeks decision only applied to federal officers, state and local police could illegally seize evidence and then hand it over to federal authorities on a silver platter, totally free of the federal exclusionary rule.
So federal courts were just using illegally seized evidence. That seems inherently wrong.
It was. This inconsistency lasted until Mapp v. Ohio in 1961, which is arguably the most significant case in Fourth Amendment history for its practical impact. Mapp fundamentally changed American policing. The court ruled that the exclusionary rule must apply to the states through the Due Process Clause. Mapp finally discarded the silver platter, making the constitutional shield enforceable nationwide.
Now, the exclusionary rule is intensely criticized to this day. We have the famous quote from Judge Cardozo: "The criminal will go free because the constable has blundered." Why, despite these costs, does the Supreme Court insist on keeping the rule?
The primary, current justification is deterrence. The rule is an institutional control mechanism. It's calculated to prevent, not to repair. It aims to deter future police misconduct by removing the incentive, the usable evidence, that motivated the illegal search in the first place. It's about forcing police departments to professionalize.
The secondary rationale, though less emphasized today, is judicial integrity.
Right, the idea that courts shouldn't be made a party to lawless invasions of constitutional rights. But really, the deterrence argument is what keeps the rule alive.
But because that social cost of exclusion is so high, the courts have been carving out significant limitations on the rule's application.
They have. The first major limitation is standing. The evidence is admissible against you unless your own constitutional rights were violated. You can't assert the violation of a third party's rights.
The second involves how the evidence can be used: impeachment.
Illegally seized evidence, though inadmissible to prove your guilt, can sometimes be used to challenge your credibility if you decide to take the stand and lie.
And finally, the complex doctrine of attenuation.
Attenuation asks if the link between the police misconduct and the discovery of the evidence has been weakened or broken. If the connection is so remote that the illegality is no longer the key driver of the discovery, the evidence might be admitted.
But of all the exceptions, the good faith exception is the most profound challenge to the exclusionary rule. It essentially asks, if the officer acts reasonably, why should the evidence be excluded?
This came from United States v. Leon. It states that evidence obtained by officers acting in objectively reasonable reliance on a search warrant that is later found to be invalid generally will not be suppressed.
But if the warrant was invalid, the search was illegal.
It was technically illegal, but the deterrence rationale fails. If the officer did everything right, presented the facts truthfully to a magistrate, and the magistrate mistakenly signed a bad warrant, well, it's the judge's mistake. Penalizing the officer by excluding the evidence achieves zero deterrence on the officer's behavior.
So the focus shifts entirely to the officer's culpability.
Exactly, and this has been expanded to institutional errors. In Herring v. United States, the court applied this exception when evidence was seized based on a negligent police record-keeping error, a warrant that had been recalled but never updated in the system.
So an innocent person's rights were violated due to institutional negligence, but the evidence was still admissible.
The court reasoned that the deterrence benefit of penalizing merely negligent conduct is minimal and doesn't outweigh the substantial social cost of excluding reliable evidence. For the exclusionary rule to apply now, the police conduct has to be sufficiently deliberate that exclusion can meaningfully deter it.
So this has been an intensive look at the Fourth Amendment, tracing its relevance from the 17th century concept of the home as a castle all the way to the modern dilemma of data privacy.
We've seen the foundational requirements. The high bar of probable cause and the need for a neutral magistrate are still the constitutional ideal. But we also spent a lot of time on the numerous exceptions justified by public safety. Exigent circumstances, consent, the low bar of reasonable suspicion, and the weakened protection for vehicles.
And finally, the complex remedy. The exclusionary rule designed to enforce these rights through deterrence, even as its own effectiveness is constantly challenged by limitations like the good faith exception.
What this all means for you is that the entire body of Fourth Amendment law is this massive shifting balancing act. It's promoting the legitimate government interest in safety against your inherent right to security, against arbitrary state action. Understanding these shifting standards is key to knowing where your rights begin and police power ends.
And as technology continues to push the boundary of what we consider private, as your phone becomes the definitive repository of your life, the question of what society considers a reasonable expectation of privacy will only grow more challenging.
Indeed. We finish where we started, discussing deterrence. Given that the Supreme Court has repeatedly expanded the good faith exception to include negligent errors in police record-keeping, allowing illegally obtained evidence to be used against you, the public is left to grapple with a profound question.
And what's that?
Are the current remedies sufficient to compel respect for constitutional rights, or does the legal system, by prioritizing the admission of reliable evidence, inadvertently signal to institutions that carelessness in maintaining those rights is an acceptable cost of fighting crime? That remains the ultimate challenge to the Fourth Amendment today.